My name is Scott Hawkins. I am president of the Florida Bar, and I first want to thank each of you for making the effort to be here for this historic moment in the history of our great state. The focus of this morning's presentation will be on the subject of the merit retention election, which will be held in November 2012. We have 3 justices on the Supreme Court who will be on the ballot and 15 state court appellate judges. But the focus today will be on the merit retention system, the merit retention elections particularly. It is our honor on behalf of the Florida Bar to take a step forward in promoting, promoting public voter education with regard to the merit retention election. In this regard, we're going to emphasize that our system has been in place for nearly 40 years and has operated under 7 governors. The Florida Bar has as one of its missions to promote the administration of justice. And in this regard, we believe promoting fair and balanced elections and fair and balanced information is essential to assist voters in Florida in making informed decisions about the election to retain the 3 justices and the 15 state court appellate judges. I want to emphasize that in preparation for this effort, this statewide effort, we have conducted research, and our research shows that 90% of the Florida voters polled do not have an understanding about what judicial merit retention means, which I think is an important consideration as you listen to the rest of our speakers. We have brought together a wonderful cast of speakers today. We think it's important to look back to see how this system came in place, to realize that the system was put in place by the voters of Florida when they passed a constitutional referendum in 1976 to put in place the system of merit selection and merit retention. And this system has worked uniformly under 7 different governors. It is my great honor to bring to the podium now one of the fathers of merit selection and merit retention in the state of Florida, if not the father, the Honorable Governor Ruben Askew. Governor Askew.
What do I do with this? They gave me a script, and if I have any strengths, brevity isn't one of them, so I'll stick, frankly, to the script. In the late 1960s, Florida's first attempt at a form of merit selection occurred when my predecessor, the late Governor Claude Kirk, who agreed with the bar to have a, quote, judicial screening program. As governor, I applied the concept of merit selection at all levels of the state judiciary. And issued an executive order in 1971 that became the basis for Florida's current judicial nominating commission system. With the passage in 1971 of House Bill 468, Florida moved to a nonpartisan competitive ballot and to a merit selection system for filling interim vacancies. In other words, the governor had the complete authority to initiate it all. I chose, frankly, to give that up as far as I was concerned for the sake of developing the merit system. The voters approved a constitutional amendment to Article 5 that would require merit retention elections for appellate judges in Florida. The amendment was approved by an overwhelming vote of the electorate, and the first merit retention election was held in my last year in office in 1978. Before the 1978 elections, appellate judges were expected to campaign for re-election every 6 years. They had to defend themselves against other candidates, but then face criticism for campaigning for the office, which by its very nature was expected to be separated from political pressure and considerations. This practice brought into question a judge's ability to be impartial and continues to be one of several issues central to the public debate regarding judicial selection. As Floridians, we should be proud of their merit selection and merit retention processes, and they help keep politics out of the courtroom and go a long way in promoting fair and impartial court proceedings. Thank you. I sit out here and I can ask questions.
Thank you, Governor Askew. It's a privilege to have heard you because you are the father of merit selection and retention. Good morning, everyone. My name is Gwen Young, and I'm the president-elect of the Florida Bar. As Scott said, our work to reach out to Florida's voters through this merit retention education program is multifaceted and will be incorporated in many different methods to share this important message. I think it will be a grassroots outreach, and this program is critical to our success. And in order to reach Floridians across the state, we'll make partnerships with key groups, many of whom you will hear from this morning. We're proud to have outstanding partners here with us today who share our commitment to the Merit Retention Education Program. Darrell Parks from the National Bar Association, Marilyn Wills, former president of the Florida State League of Women Voters, and Sandy Dallenberg, who needs no introduction. And so with that, I would turn it over to Darrell Parks.
Good morning. Thank you, Mr. Thank you very much. My name is Darrell Parks. I am president of the National Bar Association, and on behalf of all of our affiliates throughout the state, the lawyers who, especially the lawyers of color and those bar associations, we want to join in with the Florida Bar, and it's a very, very important effort. Education of the electorate is so important. And so the need to promote an educational vote should be the priority for any organization in direct contact with Florida voters. The National Bar Association is happy to work alongside the Florida Bar to ensure that our voters have access to information that will help them more clearly understand the significance of the upcoming merit retention election. As president of the National Bar Association, I look forward to working closely with the Florida Bar to communicate the importance of merit selection and its role in ensuring fair and impartial courts throughout the state of Florida. The vote's in your court, but the role of educating our voters is in our court. We are committed to doing everything in our power to promote voter participation, encourage groups across the state to do the same. Thank you so much.
Thank you. I'm Marilyn Wills, Second Vice President of the League of Women Voters of Florida. The United States is a land of opportunity because of our right to vote and our time-tested balance of powers. The League of Women Voters of Florida is part of a national organization which for over 90 years has never endorsed a candidate or party. Our mission is to encourage informed and active participation by citizens and increase their understanding of government and their essential role in making it work. The use of merit retention started in Missouri in 1940 and provides today 34 states with a system of ensuring judicial independence and accountability. As part of our ongoing campaign to help citizens across our state to be ready for all elections, our volunteers will be working this year to help voters understand this process and make informed voting decisions. We are delighted to stand here today as a statewide partner of the Florida Bar in this education program. Our volunteers look forward to continuing our 72 years of work in Florida to help voters in Florida turn out and cast an informed vote in this year's election. Thank you.
Does anybody here feel it's really remarkable to have had a governor who was willing to give up power? A person who said he cared more about the quality of the judicial system, that he would turn over the ability to name committees that would be basically campaign committees turn over that process, and to then move forward with a merit retention process. Recognize that, that what we have in our judicial system through our Constitution is not just the opportunity to go to merit retention elections, but we also have process that work to remove any judges who do wrong. We've got more ways of removing judges than of removing any other official. You can impeach judges. They're subject to the Judicial Qualifications Commission, and that process has worked at places. The thing that we need to make sure of is the merit retention system works. And Scott, I am startled at your figure of 90%. And I'm so proud of you and the others here for taking on the education program, which is so essential to turn that figure around. Thanks so much.
A few historical facts, and we'll take some questions in a minute if you have any. I want you to appreciate that Sandy Dalembert, former president of Florida State University, former dean of the College of Law for Florida State, but in particular for this morning, he was the head of the House Judiciary Committee. I won't name the date, I won't name the year, but he was the head of the House Judiciary Committee that pushed forward the formation of the amendment that was brought to Governor Askew, which led to the House bill, which was then presented to the voters of Florida to amend the Florida Constitution to put in place the system we have today, which is, again, operated uniformly under 7 different governors. So we have 2 of the founders who were there in the beginning, and Florida's system is one of the best and most widely recognized in the nation for helping to promote a stable, impartial court system. I also want to mention that Gwen Young will be the 5th woman president of the Florida Bar. She'll be taking over on July 1, and she will be leading the Votes in Your Court public voter education effort. And I know that if you have questions about the program downstream, Gwen will be available. She's from Tampa, highly regarded lawyer. She'll be available to answer your questions as this unfolds. I want to commend Daryl Parks. He's been a superb president of the National Bar Association this year. Florida as a state has had over 10 presidents of that distinguished minority bar association, the largest of its kind in the nation, probably the largest of its kind, frankly, in the world when you think about it. We are so happy to have the partners of the League of Women Voters embraced in this effort. Our goal is, again, to provide information, balanced, neutral information on the importance of the judicial merit election and the goal of an impartial, stable court system. I want to emphasize that this effort is not about supporting any particular court or any particular judge. This is not a partisan effort, and the Florida Bar is not endorsing any particular candidate. We are endorsing the system which has operated uniformly for nearly 40 years. I'm now happy to take any questions, and I greatly appreciate your being here. Thank you.
Until about 2 years ago, there was not really any organized opposition to the judges and the justices. And it looks like we're going to have even more organized opposition this year. In talking to at least one of the justices the last time, he felt, going into it with his hands tied behind his back because, these outside groups can say anything they want, but the judges are very restricted as to what they can say about their election. Is that an issue? Is that a problem?
That's a very good question. You've identified one of the oddities about, or one of the unique things about this election, and that is voting in favor of a judge is so very different from voting in favor of a representative office seeker, someone, for example, running for the state house or Congress. In that instance, those running for office can enunciate their policy views, whereas in contrast, in the context of a judicial election, a judge is not permitted by the canons of judicial ethics to enunciate their policy views. They can't explain how they may have ruled in the past or how they may rule in the future. They can't explain a policy view on an issue in contrast to someone running for Congress or the state Senate, for example. So in addition to your question, sir, very good question, the restrictions on what candidates for judicial office can say are severe and strict and strictly adhered to through the JQC process that Sandy Dalembert identified earlier. So as a result, judges who are running for office or who are actually up for merit retention are very restricted in what they can say. In contrast, those who wish to launch opposition campaigns, from what I can see, there are no parallel restrictions. And I note the obvious, that it does not appear to be a restrictive mechanism as you might have in the context of someone running for representative office. You'd have the current congressman running for re-election, and you'd have the opponent. And the current congressman can challenge what the opponent has to say. In our system with regard to judicial merit retention elections, that type of check does not exist in the system. So hence the bar believes the importance of impartial, balanced, accurate information is critical. And I appreciate the efforts of the Fourth Estate to help spread this message across Florida's vast population. Thank you for your question.
Was there any remedy for that?
Well, our focus this morning is on the election process. At the moment, I'm not in a position to comment on whether there is a remedy. But our focus today is on the November 2012 election. But you have noted what I think is a significant structural issue.
What is your, how can you, I guess, take this 90% lack of knowledge in this system and apply it to this election? What do you think the implications will mean when people don't understand, yet they see some ads from an opposition group? What is the risk here?
Very good question. I think democracy works best when there's good information. The problem you have is when the information is difficult to readily achieve. We have a lack of a historic civics education in Florida, which may be part of the issue here. But we have righted that balance, and I'm very, very proud of what the legislature has done in terms of restoring civics education. But the difficulty I see is when you don't have a real appreciation for what judges do, for the restrictions on what judges can say when campaigning. You don't appreciate what the role of a judge is. For example, if you've never been through litigation, you've never really had the opportunity to see that the role of a trial judge is largely to rule on whether to admit or reject evidence and to apply law to facts. And if the facts aren't presented, then the judge can't rule on them. And in the appellate context, the appellate judges and justices of the Supreme Court, they're confined to the appellate record. They're confined to the issues that are set forth in the appellate record as established in the trial court, and they're confined to the issues that have been preserved on appeal. The point being is if you haven't had experience with the court system, it's difficult to readily appreciate the complex roles, but the very critical roles judges play in our democracy. So you have this sort of lack of basic appreciation for the role of a judge in our democracy, and you also have a difficulty in how to assess merit. And that would be reflected in the 90% vote of those we checked with, those we polled, who seem to have a lack of understanding in terms of what the terms judicial merit retention mean. As a result of this lack of understanding, I am concerned that there will be opportunities for misinformation and no real way to check misinformation. Again, democracy works best when you have good information. And so our effort is to try to promote the distribution and dissemination of accurate, good information about the courts, the role of the courts, and how to assess judicial merit. A long answer to your very, very good question.
Would you anticipate that some of the role of this education campaign could be to explain some of the decisions made recently by the Florida Supreme Court in kind of Q&A with audience members?
Good question. To be precise, I do not anticipate that the Florida Bar will engage in an effort to explain decisions that have been made by the state appellate courts or the Florida Supreme Court. So I do not see the Florida Bar's effort as moving in that direction. I will comment on this, however. Judicial decision-making is a very, very involved, intricate exercise. And a lot of factors go into how you arrive at a decision. If you're an appellate judge, again, you're stuck with what the error was preserved on appeal and what the record is on appeal. And if issues are not within that record, you're not permitted to address them. That is an example of how complicated judicial decision-making is. Now, importantly, in our system, state court appellate judges and justices, as in the federal system, are not permitted to explain their rulings, are not permitted to explain how they arrived at their conclusions. But they all are required to uphold the Constitution as best they can. So that's how I see the Florida Bar's education effort dealing with the issue, sir.
Well, we've gone through this with teachers. Well, we've come up with, we're going to judge their merit based on the FCAT. Is there any measure of a judge or justice, how do you assess their merit?
Well, I think you should start with the fact that in our system, which again has been in place for 40 years, judges and justices are appointed as a result of a very elaborate process for selecting judges, judicial candidates on the basis of merit. They are selected on the basis of merit on the front end. And the back end, they come up for judicial merit retention elections. Again, both efforts are nonpartisan. There will be polls conducted, to your point, sir, where lawyers who have appeared before these judges and justices will be asked to give their assessment based on their experience as having actually handled cases and matters and arguments before these various judges and justices. And those polls will provide some information for voters to assess regarding judicial merit. There will be, I'm sure, a legion of articles written by both electronic media and the traditional paper media discussing merit selection, merit retention. The typical factors that are considered are: what is the judge's reputation for preparedness, demeanor, how do they treat litigants and parties, what is their reputation for scholarship, what is their reversal record, things of that nature. Those are factors that have typically been addressed over the years in terms of assessing judicial merit. Unlike the system, though, with teacher merit, there is no way to grade, what percentage of the class has moved on, what percentage of the class has gotten an A, B, or C. It's just the system doesn't lend itself to that type of quantitative evaluation.
Given the fact that both of the DCA judges involved in the Taj Mahal survived merit retention votes in the midst of that scandal, doesn't it show it's very difficult to use merit retention to police bad judges?
Well, to your question, something that Mr. Dallenbert said is very important on this point. Behind your question is the presumption that judicial merit retention elections is the system by which we police and remove bad judges. That actually is not really the purpose of the system. We have 3 mechanisms in Florida for removing judges who engage in conduct that triggers a judicial violation. We have the JQC process, which is set up by the Constitution, and that process actively reviews complaints about judicial behavior. We have instances where judges have gone through that process and have chosen to resign, and judges who've been found complicit and have been sanctioned. So that process has frankly worked very effectively over the last many, many years to police judges who have violated various judicial candidates. In addition, as Mr. Dallenbert said, we have the impeachment process. The impeachment process exists for there being actions taken up in the Senate to challenge a judge who's engaged in behavior that would trigger a violation of judicial canon. So those are 2 existing mechanisms in our system today that go to the removal of judges. And then, of course, you would have the judicial retention system that could address the issue of the removal of a judge. But I would say by the time someone gets to judicial retention, what I've observed is those instances where there's been a judge that's had a problem, typically the JQC process resolves that problem, or the judge chooses to resign, as happened with a judge on the first DCA recently.
Has any judge after merit retention ever failed to get the required vote?
In Florida, no. Elsewhere, yes.
If no one's ever failed in the state, how accurate a measure is it?
Well, again, I would say that this system's existed for 40 years. We've had, over that 40-year period of time, many judges removed for violations of judicial misconduct, judicial behavior. The fact that they have been removed prior to the judicial retention vote does not mean the retention vote is not effective. In other words, we have an existing apparatus for dealing with issues of misconduct. And please remember that under our system that was put in place through the leadership of Governor Askew and Sandy Dallenbert, our system is grounded on the notion that nonpartisan bodies select judges and nominate them to the governor at the time based on merit. It's a very rigorous process for selecting judges based on merit. So the presumption would be, absent some significant behavioral issue, that the merit that attached to the judge who was appointed in the first instance, or the justice who was appointed in the first instance, would continue. So I believe that the system has worked effectively in Florida, again, under 7 different governors, Republican and Democratic.
If it's worked so effectively over the last 40 years, why are you now having to get involved?
With Florida Bar believes that it's very important that public information, based on recent research, as I've commented earlier, shows that the lack of voter understanding regarding the judicial merit system, it's widespread and a significant concern.
Excuse me, I've got a little bit of laryngitis.
Come to the mic,
I would just add to what Scott has said. The Florida Bar has always been involved with providing information related to the merit retention system. We do judicial polls related to retention in each and every election. We've always provided a voter guide and other information, often in conjunction with the League of Women Voters. What we've done this year, because we've seen a trend of challenges to the judiciary, we've recognized that we need to sort of kickstart and uptick our education process, because we've learned that people are not as knowledgeable about it as maybe we assumed they were, and therefore, because of our obligation to support the administration of justice, we've decided we need to do more education, because 90% is not acceptable. And one of the problems when you have voters who are not educated and don't know how to evaluate is you get voter drop-off because people don't know how to evaluate a judge. We'd like to help them learn how to better do that, which then I think will give us a better turnout and a better elective retention process.
What is your opinion on lawyers who challenge incumbent trial court judges? Is that a good thing or a bad thing, do you think?
I'm all for fair competition. It is our system. The fact that a sitting judge is challenged, if he's challenged or she's challenged for good reasons, I think that's appropriate.
In Iowa, I believe it was, I think 3 justices were turned out there over the issue, I believe it was gay marriage, decision they made. Should voters, if they don't agree with the decision the court makes, is that a valid reason to vote against them?
I would say that one of the difficulties to the question over here is how do you assess merit? I think there's a serious question if a voter is led to decide a judge does not merit retention based on one particular ruling. Within Iowa, there was that one ruling you commented on, but there were a number of factors that contributed to the opposition there. And I would just point out that in Iowa, what we've been informed is that 80% of the funds that challenged those 3 justices, which then led to their defeat, came from outside of the state of Iowa. But I think it's important on your point to ask yourself, significantly, should you assess judicial merit on the basis of one ruling? Or should you assess judicial merit on the basis of the prior 6-year term that a justice or a judge has served? Our research shows that the average 6-year term for someone sitting on the Florida Supreme Court, they touch roughly 8,000 to 9,000 matters. 8,000 to 9,000 cases come across their desk in one way, shape, or form. So I ask you, is it fair to evaluate a justice on the basis of one ruling and disregard the 7,999 other matters that came before their desk? I think that's among the questions that, frankly, we need to discuss in our system of democracy as we try to bring more attention to this issue. Now, I do want to come back to the issue of merit selection on the front end, because I think your question was a very good one, and I want to ask someone who's had experience directly with the JNC process. Daryl Parks, president of the National Bar Association, has worked recently with the JNC process, where again the emphasis is on, does the nominee merit being selected as a judge, whether it be the state court appellate judge or a justice of the Florida Supreme Court? Mr. Parks.
Thank you very much, President Hawkins. As I was listening to the question and your reply about how the process works, and I'm actually a new commissioner on the appellate commission here in the 1st District, and it's a phenomenal process that we take people through who apply to be on the appellate court, where they apply, They are vetted by members of the commission in-depthly. And we have what amounts to a two-day meeting regarding these people. And so I think that when you think about the process and the great detail that the commission goes through to vet them, it's really a process that works. And probably even more important, you mentioned impartial. And it's so impartial because you have people from different parties, from different aspects of life who come together before they forward those names on to the governor. So I can tell you as a new appointee to that process, I've seen it work wholeheartedly. And truly, as you sit there, you have different viewpoints from different commissioners, but it all works together. And it's very important that you know that because you have so many different people who are coming together to make a process that, a decision they must agree on.
What would be the grounds to vote against either a judge or a justice in the merit retention process? I mean, give us some idea of what would merit a reason to vote against a justice.
Well, I believe that if there was a view that you had that a judge or justice was deciding matters that they were not competent, that they were not prepared, that they were not studiously looking at the briefs and the submittals and just arriving at their own conclusions, that they were not treating litigants and parties well, that they were not respectful of the office. I think all of those factors would be grounds for assessing merit. Those essentially are among the questions that we ask lawyers who've appeared before these courts to evaluate. Scholarship, preparedness, demeanor, attention to the briefs. Judicial decision-making is very involved.
Governor Askew said that his goal was to take politics out of the judicial retention system, or the judicial, at that point, election system. And it seems to me that what we have heard in the last few years, and I am suspecting this is what prompted your interest in this as well, is there's been a lot of criticism in the political process from the legislature of the judiciary, especially the Supreme Court. They were even attempting to reconfigure the way the court system is set up in the state. Is it really possible to ever take politics out of something like this? I mean, is politics effectively removed, or with the emergence of this Restore Justice group, is politics there inevitably?
Well, I think you need to remember this system has worked pretty well for 40 years. So for 40 years, I would say the system has been depoliticized. That's the phrase I would use, in a fairly effective manner. Now, you mentioned in your question, I'll have a couple of things I want to say, that Governor Askew's goal was to take politics out of the court system. It's important that it was the voters of Florida. The voters of Florida chose to amend the foundational document that governs our state to put in place this system that exists today, and the effort was to depoliticize the selection of judges. Governor Askew and Sandy Dalembert, they were there to help lead the effort. But the Florida legislature passed the bill that later put on the ballot this referendum, and it was the voters of Florida who adopted the amendment to the Constitution overwhelmingly. So presumably it was the voters of Florida who were seeking to depoliticize the selection of judges. And please remember, I urge you to read Martin Dyckman's book, A Disorderly Court. You know, there's quite a bit of discussion in that book about difficulties within Florida's judiciary that were plaguing Florida's system back before this amendment went into place. And I would just point out at the time, as has been noted, judges ran for office and they campaigned and they raised money like those running for representative office, whether it be Attorney General or Agricultural Commissioner. I don't mean anything about that except to say it was the voters in Florida who chose to depoliticize the system. Now, we live in a political system. We live in a democracy. You're always going to have tension between how one party views things versus another. But I will say the system that we have in Florida is modeled on the Missouri system, and it's been in place, as I've said, nearly 40 years. There have been efforts across the nation, I believe roughly 30 of the 50 states, slightly higher than that, I believe, have this system in place of merit selection and then merit retention, both efforts nonpartisan. There have been attempts in the past to displace those merit systems, to get rid of the merit selection and merit retention system in those states. And those attempts have always failed. The point being, the voters rejected the efforts in those states to put back in place a system that some might say, instead of depoliticizing the court system, would repoliticize the court system. Again, the Florida Bar's position, look, our system has worked uniformly well for nearly 40 years. And we've had a fairly stable and impartial court system over 40 years that's fairly well regarded in this nation. The Florida Bar, in keeping with its commitment to promote the administration of justice, believes it's important this year to ensure and enhance the level of voter education out there. This effort, to your first point in your question, is not the direct response to any actions of the legislature. It is really recognition of an important issue that the Florida Bar believes it needs to speak out more loudly on than it has in the past.
You know, it seems though, as you point out, the system has worked very well for the last 40 years, but nobody has lost. That would seem to suggest that, you know, you also have perhaps a frustrated public with the courts at times, that the public is not able to unseat a judge they would like to unseat.
Well, importantly, over that 40-year period of time, there have been a number of judges removed.
By other means.
By other means that are within the system.
Is merit retention a good up or down vote on a justice when apparently the public has not found any one of them to be so wrong that they would vote them out or be capable of voting them out?
I would say the system has worked uniformly. The premise behind your question is that justices have been permitted who misbehaved, and that has not been the case. I'm trying to emphasize we've had a number of judges who have been removed through the existing structure, and that needs to be part of the story, because people think judicial retention is how you get rid of somebody who misbehaves. That was not the way the system was conceived to begin with. The system was put in place through the constitutional amendment to give the voters an opportunity to vote on the assessment of merit.
And just to get back to Iowa, was the result there, did that expose a flaw in the system, or is that the way it's supposed to work?
I'm not going to be able to comment specifically about the Iowa situation and occurrence. I'm struck by the fact that, from what I've learned, 80% of the money that came in to attack the system in Iowa came from out of state, and that is of concern.
Should we should perhaps restrict funding of groups that oppose judges in some way?
Our focus this morning is on the election in November. The Supreme Court has taken, the U.S. Supreme Court has taken certain positions, and I'm not really in a position to comment on your suggestion.
Should voters take judges' decisions into account then when they vote? Is that something appropriate for them to consider?
I think it's important that voters take into account judicial records. And judicial records involves a body of work and a general reputation for preparedness, scholarship, effort. Taking one decision and using that as the bellwether for how you decide, I question whether that's really a judicious way to assess merit. But that's my own personal view. But we think that the system is about assessing merit in general. And on that point, I thank you very much for your time, your attention, your very good questions. And I want to thank our panel again, Governor Askew, Sandy D'Alembert, Darrell Parks, Ms. Wells from the Florida League of Women Voters, and thanks to all of you for being here. Thank you.